Hello and welcome to BYJU'S. September 2018, a five-judge constitution bench of the Supreme Court decriminalized adultery. In this lecture, let us look at some of the most important highlights of the judgment, beginning with the text of Section 497 of Indian Penal Code, which defined adultery. The text is right there on your screen, but let me make it very simple for you. There's a husband and there's a wife. Now enters an outsider. If this outsider develops sexual relationship with the woman, then it is adultery and this outsider shall be prosecuted. What will happen to this woman? No case can be filed against her, but I will tell you slightly later why. But why should this outsider be prosecuted on the grounds of adultery? The reasoning given was, the rationale given was, that this wife is the property of the husband. And since this wife is the property of the husband, and this outsider is trying to snatch this property, then it's a classic case of theft, and as such, this outsider shall be prosecuted for adultery. But let me tell you two things here. If this outsider develops sexual relationship with the wife, but with the consent of the husband, with the permission of the husband, then it is not a case of adultery. No case can be filed. Point number two. If this husband develops sexual relationship with an outsider, and this outsider can be an unmarried woman, can be widowed, can be divorcee, even then it is not a case of adultery. Why? Because wife is the property of the husband. Husband is not the property of the wife. So someone is not snatching husband from the wife because husband is not the property of the wife. Now the question before the court was whether Section 497 of Indian Penal Code, whether it is constitutional or it is unconstitutional. But to understand that, we need to first ask, why did the British era law exempt women? Why were women not prosecuted under adultery? To understand this, first we need to understand what is the difference between a civil wrong and a criminal wrong. A civil wrong is basically a matter of dispute between two individuals. For example, you and me, we are having a dispute over a piece of land, over a piece of property. Since it's a dispute between two individuals, it's a civil wrong, it's a civil case. But a criminal wrong or a criminal offense is an offense against the state, or it is an offense against the society. For example, terrorism. Terrorism is an offense. It is a criminal offense because terrorism is an act of crime against the state. Similarly, murder, dacoity, rape, these are offenses against the society, and as such, these are crimes. Because murder, dacoity, rape, they have the potential of destabilizing the society, and as such, these are crimes and these are criminal offenses. The first Law Commission of 1837, which was presided over by Lord Macaulay. Lord Macaulay did not include adultery as a crime. No. Instead, adultery was included as a civil wrong because it is a dispute between two individuals, husband and the wife. Let them deal with this. But then the second Law Commission, which was presided over by Sir John Romilly, that adultery was included as a crime. But even after it was included as a crime, but women were spared from conviction. They should not be prosecuted. But why women were spared conviction? Primarily because of the conditions they lived in. For example, polygamy was rampant. Similarly, huge age gap between the spouses, child marriages. Since the conditions in which women found themselves in, since these conditions were against the women, anti-women, that is why a protection was given to the women that you will be spared prosecution under adultery. And in fact, there was a notion at that point in time that man is always a seducer and women is always a victim. That is why even if a woman is involved in an adulterous relationship, it is the fault, it is the wrong of the man, because man is always a perpetrator and woman is always a victim. That is why this British era Indian Penal Code exempted women from being prosecuted under the adultery law. But after the Constitution was enacted in 1950, a challenge was filed in the court against this adultery law. The case was Yusuf Abdulaziz versus State of Bombay, 1954. The question before the court was that since under adultery law, only men are prosecuted, only men are convicted, it goes against the fundamental right to equality under Article 14 of Indian Constitution. Supreme Court said, no, that is not the case. Why? Because under Article 15, Clause 3, the state has been given the power that you can make special provisions for the benefit, for the upliftment of women. And this provision under 497 IPC, wherein a woman cannot be prosecuted for adultery, it is a special provision in favor of women. Few decades later, in 1988, Revati versus Union of India, Supreme Court made the same position known again, that Section 497, which prohibits a woman from being prosecuted for adultery, is a reverse discrimination in favor of women. But now let us look at what is the status of adultery under the Hindu and Islamic laws. Manu, for example, Manu Simriti gives a very broad definition of adultery. When we say very broad definition of adultery, that means there are various activities and actions that can be termed as adulterous. For example, if you are giving present to a married woman, it is adultery. If you are roaming around with a married woman, it is adultery. If you are touching the ornaments or the dress of a married woman, it is adultery. If you are sitting with a married woman on bed, it is adultery. If you are having sexual interaction with a married woman, it is adultery. And the punishment for adultery is death, with only one exception. If the offender is a Brahmin, no punishment can be given to a Brahmin. Otherwise, the punishment for adultery is death. Under the Islamic law, there is a very narrow definition of adultery. When we say very narrow definition of adultery, that means adultery is a married woman or a married man having sex or having sexual intercourse outside the marriage. That is adultery. But under Islamic law, it was very difficult to prove adultery. How? For example, I am leveling an accusation against an individual that these two individuals have committed adultery. To prove adultery, I have to bring 4 witnesses. 4 witnesses who are the witness to their sexual relationship. Since it is very difficult to get 4 witnesses who are a witness to a sexual activity between 2 individuals, as such, it was very difficult for me to prove this adultery charge. And in return, I will be given 80 lashes because I have made a wrong accusation, a wrong charge, an incorrect charge against an individual or a couple. This was the position of adultery under the Islamic rule and the Hindu laws. But now let's come to the verdict. A 5-judge bench of the Supreme Court, headed by Chief Justice of India, Deepak Misra, declared that Section 497, which criminalizes adultery, is unconstitutional. Let us have a look why. The Supreme Court in its verdict said that we are striking down Section 497 because of its manifest arbitrariness. Why? Under Article 14 of Indian Constitution, we have the right to equality. Not only do we have right to equality, we also have a fundamental right against arbitrariness. That's our fundamental right. Since Section 497 only penalizes men and not women, it is manifestly arbitrary and as such, it is unconstitutional. Another reason given by the Supreme Court was that Section 497 of Indian Penal Code, it treats women as the personal property of the husband. Since it goes against the dignity of a woman, as such, it is unconstitutional. In fact, Chief Justice of India said, husband is neither master of his wife, nor does he have legal sovereignty over her. He observed that any system treating a woman with indignity invites the wrath of the Constitution, and that is why adultery is no longer a crime. Justice Nariman made a beautiful observation, and this observation can have far-reaching consequences as well. Justice Nariman said, under adultery law, only a man is convicted, but a woman is not convicted. Clearly, this goes against Article 14, which is about right to equality. But this goes also against Article 15, which says there can be no discrimination on the ground of sex. Why is it that we are discriminating against a man? Justice Nariman made an even more important point. He said the ancient notions of man being the perpetrator and women being the victim no longer hold good. There are various constitutional experts who say that this reasoning of Justice Rohinton Nariman will pave way for a gender-neutral law in this country. And maybe under this logic, man can also file a rape case against a woman. But Justice D.Y. Chandrachud made an even more important argument. Justice Chandrachud said, when husband and wife, they marry, wife has not given up on her sexual freedom, on her sexuality. She can also explore sexuality outside the marriage as well. So since at the time of the marriage or even afterwards, the wife does not lose her freedom, her control over her sexuality, and Section 497 deprives the woman of her sexuality, of her sexual freedom, it goes against the very concept of privacy and dignity under Article 21 of Indian Constitution. But Justice Indu Malhotra, the only woman judge on the panel, made an even more important observation. She said that adultery, yes, it can be a moral wrong. That means morally an adulterous relationship may be wrong. But this is a case to be decided by the husband and the wife together. So at best, it can be a civil case. It cannot be a crime. How can adultery be crime against the society or be an offense against the state? It clearly is not the case. But based on this ruling, Supreme Court said adultery is decriminalized. But Section 497 can still be used. Why? It can be used as a ground for divorce. That means if a husband or a wife, they are entering into an adulterous relationship outside the marriage, it can be a ground for divorce, but it is no longer a crime. Adultery is decriminalized in this country. These were the arguments put forward by the 5 honorable judges of the Supreme Court who decriminalized adultery. This is all that you need to know regarding the adultery verdict of the Supreme Court. If you want more such videos, please like this video, comment under the comment section, and subscribe to our YouTube channel. Thank you. Have a great day.